confusing and complex following Supreme Court decisions in 2001 and 2006. For nearly a decade, members of Congress, state and local officials, industry, agriculture, environmental groups, and the public have asked for rulemaking to provide clarity. There has been some confusion about the proposal, and the agencies want to provide the facts. This webinar will address some of the more common concerns and misconceptions about the proposed rule, particularly for the agricultural community. Without further ado, I want to introduce our speaker for today. Our speaker is Ms. Nancy Stoner, who is the Acting Assistant Administrator for the Office of Water at the U.S. Environmental Protection Agency, where she leads the agency's work to protect the nation's water resources. Ms. Stoner's career in environmental policy and law began in 1987 as a trial attorney in the Environment and Natural Resources Division at the U.S. Department of Justice. She then served as Director of the Office of Policy Analysis in EPA's Office of Enforcement and Compliance Assurance, and co-director of the Water Program at the Natural Resources Defense Council. She is a 1986 graduate of Yale Law School and a 1982 graduate at University of Virginia. The proposed rule that EPA and the U.S. Army Corps of Engineers put out back in April was put out jointly between EPA and the Corps. We also have on the phone with us today three of our colleagues from the Army Corps of Engineers: Jennifer Moyer, who's the acting chief of the regulatory program; William James, who is the acting deputy chief of the regulatory program; and Stacy Jensen, who's on staff of the regulatory program. And now, without further ado, I will turn it over to Nancy Stoner, EPA's acting assistant administrator for water.
Great, thanks, Jim. And thanks everybody for joining us this afternoon. It looks like we have more than 1,100 people on the webinar today. So terrific that you are taking the time to join us and to hear this update. For those of you who were on the webinar earlier that we had a couple of months ago, some of this will be familiar to you, but we did add a lot of information to address misconceptions and misinformation. So there'll be some new material at the end that I hope will be helpful to you. So I'm going to jump right in. We will have opportunity and time for questions at the end. So you can go ahead and start sending those in by typing them in, or we'll also have some time at the end to respond to those questions. Okay, so the first slide, the most important thing right there in the first slide is that this is a joint rule. EPA and the Army Corps worked together to develop this in a series of meetings together, and went over not just the concepts, but every aspect of it together. And we are here together on this webinar to talk with you about it and to explain our thinking with you today. The purpose of it is to clarify protection under the Clean Water Act, of the scope of the Clean Water Act, and we'll talk about that in more detail as we go through. So the next slide is about the objectives of the Clean Water Act. So as you know, the Clean Water Act was passed in 1972, and then it was reauthorized by Congress in 1987. In both of those cases, it was a strong bipartisan effort to pass legislation. I think of it as them thinking at that time of us, of future generations, and how they could ensure that we would have water resources that were usable by the public. Very much focused on how people use waters and making sure that they were safe for use. The quote there, as you see, restoring and maintaining the chemical, physical, and biological integrity of the nation's waters, very much focused on pollution and the pollution incidents of that time, the burning of the Cuyahoga, the declaration that Lake Erie was dead, and so forth. It was focused on addressing those major sources of pollution to make sure those water resources would be safe for use. And the term that Congress used was waters of the United States. And there isn't a definition in the statute about waters of the U.S. It says the term navigable waters and waters of meaning defined in the statute as waters of the U.S., including the territorial seas. So, as again, we'll talk about in a little more detail, the Supreme Court has looked at this question at least 3 times and indicated that this is not navigability, was not the focus, wasn't about navigation. We already had the Rivers and Harbors Act in 1899. It was about navigation. This was about pollution and protecting waters that link to the navigable waters. The navigation being the word navigable being the jurisdictional link or the national link, congressional link, but protecting those stream systems and protecting the pollution. Again, we'll talk a little bit more about it, but the basic idea is to protect the entire stream system. It's important to keep in mind that there is already a regulation on the books defining the waters of the United States, and that's on this slide 5, lists all the elements, what's in there now. So this proposed rule would not for the first time define waters of the United States, but instead take the Supreme Court precedents and make sure that the current regulatory definition matches up with what the Supreme Court has told us about what the Clean Water Act means, and linking that with the science, which is one of the strong messages we got from the Supreme Court, is to look at the science to make sure that what we're doing will be effective in protecting those waters. So that's what we're looking at. The next slide shows that only the last 3 elements of this are proposed to be changed in any significant way in the proposed rule. So the first 4 the same, basically, and then we're going to talk about what those proposed changes are to that area that's circled there on the slide. Next slide. So we're going to focus in this discussion on streams and wetlands. There's general agreement on coastal waters, territorial seas, the Great Lakes, and so forth. Everyone recognizes that those are waters of the United States, and what we are focusing on here is the streams and wetlands that are directly related to those and necessary to protect in order to protect those larger, more iconic or charismatic waters. This, again, is information that's probably familiar to most of the people on the webinar, but the major functions that we know that streams and wetlands provide, trapping floodwaters, recharging groundwater supplies, removing pollution, providing habitat for fish. So the basic idea there is that most of the water, actually, and most of the stream miles are in those smaller streams and wetlands, and those are the functions that we lose if we don't have effective protection of those waters. And then, of course, streams and wetlands are economic drivers. In fact, the surface waters in general are huge economic drivers. Pretty much every job in the United States is dependent on some way in having access to adequate, usable water supplies. So on the slide, we identify hunting, agriculture, energy generation, manufacturing, recreation, fishing, pretty much anything. Again, you can't have a business very much unless you have access to water resources that people can use. And streams and wetlands, again, that's where most of the water is. That's what you need in order to make the economy function. And then on to the next slide, upstream waters impact downstream waters. This is a pretty basic scientific principle, but very important because 60% of the stream miles in the United States only flow seasonally or after the rain. They have a huge impact on downstream waters. You really can't effectively protect those bigger rivers, lakes, coastal waters unless you're protecting the waters that flow into them. That is a basic premise of this effort. And of course, one of the things that streams do is provide drinking water. So about 1 in 3 Americans get their drinking water from public water systems that rely, at least in part, on seasonal and rain-dependent streams. You can see the map there. You can see where people are getting that surface drinking water. And the dark area, the dark red, is 90 to 100% of the population, depending in part on these streams. So they are really critical across the country for providing safe drinking water. And that's one of the great things that we have in the United States. You can go pretty much anywhere in the United States and you have safe tap water to drink. And I'm sure many people on the webinar have been to countries where that isn't the case. And it's, not just an inconvenience, it's a danger. And so here in the United States, that is one of the things that we get from the Clean Water Act and the Safe Drinking Water Act working together to provide that safe tap water to Americans. So why are we doing this rulemaking? So I've talked a little bit about the purposes. Now I'm going to go on a little bit to sort of the background and the context. The first thing is the three Supreme Court cases. So I mentioned these already. These are the three cases that very clearly indicated that the Clean Water Act does not just provide waters that are used for navigation, but protects adjacent wetlands and other water streams and so forth as well. And the other thing that they did, while affirming that broad reach of the Clean Water Act and how it has been interpreted over time, they narrowed the scope from what it was thought previously before 2001. So the Clean Water Act was thought at that time to protect waters based on use in interstate commerce or linked to interstate commerce, including use by migratory birds. The Supreme Court said in the Swank case that you see there on the slide from 2001 that wasn't the right basis, and really it emphasized the science and the connections between waters as being very important, more so than the interstate commerce link. So that narrowed the scope of the Clean Water Act at that time, and one of the main things we're trying to do is to match the regulations with that narrowed scope that the Supreme Court told us was appropriate for interpreting the Clean Water Act. The other thing, as you see referenced in the Rapanos case there in 2006, is that we got a bunch of different opinions there, and really a lot of, and we actually got encouraged by the Supreme Court itself to address it due to the different opinions and the confusion that there was reflected in those Supreme Court cases about the scope of the Clean Water Act. So a narrow jurisdiction and a confused jurisdiction. So one of the things that we're doing is to try to reduce confusion about the Clean Water Act protection. So that's one of the main purposes. Really, what's in and what's out are the two main purposes: better protection for the waters that are in, and more clarity about what's out. And as the slide that's up right now indicates, the rulemaking was requested by lots of different people from different perspectives: Congress, industry, public, state and local government, agriculture, hunters and fishermen, environmental groups, and of course, as I mentioned already, the Supreme Court itself. Justice Roberts urged us to clarify the scope of the Clean Water Act, since it wasn't clear and since that statute is so important to the American public. So following the guidance of the Supreme Court, we are looking very closely at the science, and we asked the Office of Research and Development to help us to do that. And what they have done is an analysis of more than 1,000 pieces of peer-reviewed scientific literature, published scientific literature. The report is called The Connectivity of Streams and Wetlands to Downstream Waters. You can see it. It's available on our website. It is currently undergoing review by EPA Science Advisory Board, which is an independent board that advises the agency on science issues. And that process is underway. We've already gotten some initial feedback from the Science Advisory Board. The rule will not be finalized until we receive the final feedback from the Science Advisory Board. We revise the science document that the Office of Research and Development has taken the lead on drafting for us. Those will be final by the time that the rule is finalized, so that we will have that good, strong science background for the decisions we make. And the thing that's important about that is not just that it is good science, but that it means that the effort that we're undertaking collectively as a society is likely to work. That where we are putting protections in place, where we're requiring permits and so forth, that's actually going to protect the waters. Those dollars will be well spent to achieve the objectives of the Act. And that leads me to costs and benefits, which is up on the current slide. As you see, there are analysis of the benefits and the kinds of benefits we looked at on the left, and the costs and the kinds of costs we looked at on the right. And the benefits are roughly twice the costs, even if you look at the highest cost estimate and the lowest benefit estimate. We still estimate a benefit to the public in this rule, and finalizing this rule and its protections. And some of the benefits are those same functions that I mentioned earlier: reducing flooding, filtering pollution, providing wildlife habitat, supporting hunting and fishing, and recharging groundwater. This is something that's been of significant interest already to the public, how we did this benefits analysis, and we will be making refinements based on the comments we receive over time. We will have a final benefits and cost analysis to support a final rule. And then one of the things that we think the rule will do is save businesses time and money. So the clarity from what's in and what's out, businesses knowing what they need to do to comply with the Clean Water Act, but also knowing that they don't need a jurisdictional determination if a water is out. That will speed up the whole jurisdictional process, save businesses time and money. Also save federal governments, state governments, local governments, all of those of us who work together to implement the Clean Water Act, time and money as well. So real benefit to our society in terms of efficiency. So the other thing about the Clean Water Act is that it is based on a cooperative federalism approach, where the federal and state governments work together to implement the statutes. For example, 46 states implement the pollution permitting program, or the NPDES program, and 2/3 of the states rely on the federal definition to determine which waters to protect. States are allowed to do more than what the Clean Water Act applies to. They can protect additional waters if they choose to do so, but 2/3 of them use the federal definition. Okay, so now I'm going to do what the rule does, and then we're going to do what the rule doesn't do. So this is what the rule does part. So as I mentioned already, one of the main benefits that we think we get is better protection of stream systems, particularly focused on seasonal and rain-dependent streams, and I already indicated what a great value they provide and how important protection of those streams is to the downstream waters. So that's one of the main things that we think we get from the proposed rule. So let's look at the rule changes here. So what we're protecting, we call them streams here, but tributaries is what they're technically called. The rule has a definition of tributaries. That's the first time we would have such a definition in the federal rule, and it's on this slide. Waters with bed and banks and an ordinary high water mark that contribute flow to traditionally navigable waters, interstate waters, or territorial seas. So there's a couple of different elements that are important to look at here. So waters with bed and banks and an ordinary high water mark. So that's a limiting definition. It's one that says things that are not tributaries and are not waters of the United States. That's the first time that we've done that. And then what do they have to contribute flow, so they do have to be what we think of a normal, layperson thought of as what is a tributary, one that contributes flow to downstream waters. And the ones they have to link to are the traditionally navigable waters, interstate waters, or territorial seas. And so that links up with the Commerce Clause element, and with as well as with the science and so forth. That these are waters that have that crossing state borders is part of what I think about. The territorial seas, international crossing state borders, or they're used traditional navigation. So that's how we link up with the legal test. And then the other thing we get is that waters near rivers and streams are protected. Those specifically located in floodplains and riparian areas, and those with a direct connection to those stream systems. So again, based on the science, it tells us that those waters have an effect, a significant effect or substantial effect on the rivers and lakes and streams. And so that's what the rule relies upon. Most of those waters are protected today. Honestly, again, these are waters that have been historically protected. This makes it faster to protect them, and again saves time and money to do that by saying they're protected as a group instead of having to do an individual case-specific analysis of these waters. A couple things here on the slide on the rule changes. So adjacent waters are jurisdictional. If you look at the rule today, that's what it says. What this does is clarify that applies to all surface waters, not just wetlands. And so if you have a surface pond or some other kind of water like that, it's jurisdictional, or Oxbow Lake, something like that. And existing regulations, again, have adjacent, bordering, contiguous or neighboring, and this rule would add a definition of neighboring, and that's where where it picks up the reference to the floodplains and the riparian areas. So those would be the areas where they are naturally connected to the stream system. And then other types of waters will be evaluated on a case-by-case specific or case-by-case basis. That's what we do today, and that's what the proposed rule will continue. We did ask for comment on this issue of other waters because it doesn't have as much clarity as the other aspects of the rule, because this case-specific determination needs to be made. So we asked for comment on that, whether there's any way to do that in a way that's also more efficient. And then this is an important slide. I think this is a slide that shows how this works in the landscape. So looking at the top left, you'll see that seasonal and rain-dependent streams, those are part of what we're protecting. Wetlands or other surface waters there with a surface connection, direct connection to the stream system, year-round or perennial streams, rivers, of course, and then wetlands and surface waters in floodplains or riparian areas. Not the floodplain and the riparian area itself. I think we have a slide on that later, but the water that's located there. And then on the right, you'll see floodplains themselves, not jurisdictional. There are lots of other things that we'll go over also. And then the other waters evaluated on the case-by-case basis. So those other waters, those are the ones that are not either the stream or river itself or in the floodplain or riparian area. Those are continue to be evaluated on a case-by-case basis for the significant nexus to those downstream waters. Okay, so we worked really hard to make sure that the proposed rule doesn't have a negative impact on agriculture, that it actually benefits those involved in farming, ranching, and forestry. We think that is the intent of Congress, as reflected in the various exemptions and exclusions that I'm going to talk about that apply to agriculture, but it's also because agriculture is a good land use from a water quality standpoint. Very beneficial to have working lands and to have the stewardship associated with agriculture to protect the downstream waters. So we worked hard to make sure that we thought about those issues, we got input on those issues, and that we address them the best we can. And that's what the next slide says, that we did get input for the past 3 years. We listened to input from the agricultural community, and we put in a lot of various things that we put in the rule proposal to address the input that we did get. We do hear a lot of concerns in the agricultural communities. We're continuing to do a lot of outreach. I believe Ellen's in Texas right now on an agricultural tour and to do a roundtable there. We've been doing a lot of those with our regional offices, and the Army Corps has been involved in a number of those with us. so that we can continue to work on it. This, of course, is a proposal, so we can continue to work on it to make sure we get these issues right for the final rule. And I'm not going to read all the words on this page, but this and the next slide are about all of the exemptions and exclusions being preserved. So every single exemption that we were able to find in the statute, the regulations, or the guidance, they're all here. They're all in the proposed regulation. If you think there is one that we missed, please let us know about that in the comment period. We think we got them all. So you can look at them here in the slide that preceded it. These are all the exemptions that you would find in any guidance document, rule, or statute. They're all here. And then, so the next thing is about the interpretive rule. So we've been talking so far about the proposed waters of the U.S. rule. In addition to that, the Army Corps and EPA and USDA worked together on an interpretive rule that was announced at the same time as the proposed rule, but it's a separate document. And the idea of it is to incentivize conservation practices. I referenced already the fact that farming, and particularly the good stewardship activities that farmers engage in are beneficial to water resource protection. Conservation activities are particularly beneficial. So what we did with our colleagues at NRCS as well as with the Army Corps is to identify 56 conservation practices that are good for water quality and at least sometimes occur in waters of the United States. And we interpreted an exemption that's already in the statute in 404F, which is for normal farming, ranching, and silviculture or forestry activities. We interpreted that so that these 56 practices would clearly be covered by that. So they're added to the normal farming practices, farming, ranching, and silviculture practices that were underway already. These would be clearly exempt from the dredge and fill permitting requirements without any additional paperwork. So the idea was really to incentivize those practices by saying those engaged in the activities, farmers, ranchers, or foresters, could go ahead and do these conservation activities that would provide water quality benefits. They could do so without consultation in advance with EPA or the Corps, or even with NRCS, although of course they could ask the NRCS about their conservation practices. I think the next slide on that. Okay, so that's it on those conservation practices. And we did make it immediately effective, so that it would be effective during the farm season this year, and we will be taking a close look at that next fall, again with USDA and the Corps, to see whether we got the conservation benefits we were looking for, and how we would tweak that to make sure that we do get the benefits that we're looking for, and to make sure that this is reflective of our intention, which again was not to take away any exemptions, but rather to clarify an exemption and make it easier for farmers and ranchers and foresters to obtain. Okay, on to input is important. As I mentioned, we have already gotten a huge amount of input. As you may know, before doing this proposed rule, we also worked on a guidance with the Army Corps of Engineers. We got input on that as well. So we've had more than 4 years of dialogue on these basic topics and the substance of these issues, more than 415,000 comments that we have received over the past several years. But we aren't done yet. We've got until October 20 to continue to get comments. We extended the comment period, so it's a full 180 days, which is a very long comment period. And we did so at the request of lots of different stakeholders who said they wanted more time to look at it and to comment. We gave them that time, and we will be considering all of the comments we receive very closely as we move forward to make sure that we've got all your good ideas so that we can make an even better rule when we finalize it. So this slide is how to comment on the proposed rule. So this is the docket. All of the comments go into a docket in the federal e-rulemaking portal. There, you'll see the website, and you just follow the instructions. And as I said, you have till October 20th to put those comments in, but you don't have to wait till October 20th. Go ahead and put them in now if you're ready to go in terms of the comments that you have. And we're looking for overall comments. You know, I like it, I don't like it, here's why, as well as very detailed comments. I think this word should be changed to that word. I think this concept could be better explained. All of that will be very useful to us, and we'll be looking at it all very closely with our colleagues over at the Army Corps. And as I said, we're doing a lot of outreach. There have been more than 120 meetings already since the release of the proposal, and then you'll see the states there listed. Those are just the agricultural roundtables that headquarters is participating in. The administrator herself was out in Missouri last week. This is a key priority for her and for and as well as for the Army and the Secretary's office over there. So we're going out, we're talking and focusing particularly on agriculture because we have heard some concerns from agriculture. We want to make sure we understand those and we can address them the best we can. And we are really trying to, as I say, not only listen to those concerns, we want to have a real conversation about the real issues. One of the problems that we've had and that this webinar is hopefully will help to address is there's been a lot of misinformation that is being is on the airwaves, is in the media, and we don't want to spend all of our time talking about things that are not in the proposal. We want to talk about what's in the proposal. Let's talk about what it really says, what the real issues are. Let's make it good by working together. That's our goal. So one thing we did is to put up some materials to help dispel the myths. So we're calling it Ditch the Myth. It includes the speech that Administrator McCarthy gave in Missouri last week that I referenced already, has Q's and A's that I hope will help answer questions that you have, responses to some of the misconceptions, puts up editorials, opinion columns, and so forth. A lot of good information from you representing our perspective. I understand that some people have different perspectives. That's what we're trying to understand. But here is information that we feel very confident you can rely on in understanding how we intend the rule to work and what it means to us. So then I went over what the rule does do, and I went over the Ditch the Myth. Now we're going to talk about what the rule does not do. And there's more information like this up on that Ditch the Myth website so that you can take a look at it yourself after the webinar today. Okay, so the first thing is about the fact that this is a rule about the jurisdiction or the scope of the Clean Water Act, which waters are protected under the Clean Water Act. It is not a permitting rule. It does not change any permitting requirement for anyone. So it's just not about permitting. It's about which waters are protected. But the Clean Water Act does not require anyone to get a permit unless they are discharging a pollutant from a point source into a water of the United States. So that will not change. So the way we think about it, if you're not polluting, you're not destroying a water, you don't need a permit. And only point sources are required to get permits under the Clean Water Act. And that definition, which is in the statute, is not being changed. So in general, you're engaged in an activity, doesn't require actually not just in general. If you are engaged in an activity that doesn't require a permit today, it won't require a permit tomorrow because we didn't change those. And then the proposed rule doesn't include any waters that have not historically been protected under the Clean Water Act. So I went over this a little bit already when I talked about the Supreme Court cases. The proposed rule reflects the more narrow reading of Clean Water Act jurisdiction established by the Supreme Court. The current rule that's on the books is broader than that. So we are narrowing the regulatory types of waters that were not protected in the 80s and 90s that would not be protected, that would be, I'm sorry, I said that backwards. There's no waters that were not protected in the 80s and 90s that would be protected here. It's only a subset of the waters that were previously protected, and fewer waters overall than what was protected in the 80s and 90s. That's due to the Supreme Court cases in Swank and Rapanos narrowing the scope of the Clean Water Act. Now, one of the things that I mentioned earlier was inconsistency or confusion about what the scope is. So because of that, sometimes people think that certain waters weren't protected, which were protected. But it's no new types, just more consistent protection of a subset of the waters that were previously protected. Okay. Sorry, I'm behind. All right. So another concern is been raised is this going to give EPA and the Army Corps greater power over water on farms and ranches? Again, no change to permitting requirements, nothing different there. All the exclusions and exemptions from jurisdiction, and there are also exemptions from permitting requirements. We talked about the 404 exemptions earlier for normal farming, ranching, and forestry. The proposed rule doesn't change or limit any of them. What it does do is make sure all of them are in the rule so that it's very clear that they apply. And then, again, the second part is about the interpretive rule that we worked on with NRCS and those agricultural conservation practices. So we're clarifying exemptions by putting them in the rule. We're not removing any exemptions. There's another myth out there about the proposal expanding jurisdiction on ditches. I can't tell you how many times I've heard that. That is just wrong. So some ditches have been regulated since the 1970s. The proposed rule does not expand jurisdiction over ditches. What we're doing is clarifying that ditches that are constructed in dry lands, that drain only dry lands, and don't have perennial flow are not waters of the U.S. That's most roadside ditches and ditches collecting runoff or drainage from crop fields. The ditches that are generally in are ones that are essentially streams. They're just human altered or paved over or streams, channelized streams, that's the word I'm looking for, which feed the health and quality of larger downstream water. So they're essentially streams. So there isn't a legal definition of a ditch. The question is, what is a ditch? What is a stream? Well, if it functions like a stream, then it has historically been protected. The agencies have always protected those kinds of ditches and regulated activities that discharge into them from a point source. Those that are out are those that are dug in dry lands, drain only uplands, don't have perennial flow, or don't flow into a jurisdictional water. So I've been out on farm fields, people show me something, it doesn't flow into a downstream water, that's not a tributary, that's not regulated. In most of the agricultural ditches that are involved, those are ones that are dug in uplands and drain only uplands. So those are out. So the main thing to keep in mind is either it's an altered or channelized stream. Those have always been protected. They would still be protected if they meet the definition of tributary, which, as I already told you, is a limiting definition. And then the ones that were by practice out, the ones that were out that was in the guidance from 2008, that exemption would now be right in the regulation, so that it would be very clear that those ditches would be out. Okay. Proposed rule won't apply to wet areas on fields, erosional features on fields. You have a wet spot on field, that is not going to be a waters of the U.S. We didn't change the definition of wetlands. That's one thing that's very important for people to know. So if it wasn't a wetland already, it's not a wetland now and is not a water of the U.S. And then there's concern about ponds. You see there's the administrator looking at a pond that's not the water of the U.S. There's exemptions already already for farm and stock ponds. There's an exemption from jurisdiction. There's an exemption from permitting. They don't change any of that. Those are exempt. And then EPA and the Army Corps are not proposing to protect groundwater or shallow subsurface connections. So again, groundwater and shallow subsurface connections, this has been our practice already, not to call those waters of the United States. This would put it right in the rule. That would make it very clear. People would know that they were not being considered to be waters of the U.S. If you have a subsurface connection, it can connect up waters of the United States. There can be a connection between surface waters, but those subsurface connections, tile drains is the best example of those. Those are not treated as waters of the U.S. The proposed rule doesn't mean permits are needed for other kinds of normal farming, ranching, and silviculture activities. Walking cows across a wet field or stream was an example that we saw out there. You don't need a permit for that. And then I mentioned this earlier, but just to clarify it one more time here. So the 56 conservation practices that we identified with the Corps and USDA as being the conservation practices that we wanted to make it easier for farmers to do. Those are not the only normal farming practices, but again, we wanted to make sure it's very easy for farmers to do those practices. So we incentivize them by saying you didn't need to ask anybody, you don't need to do any paperwork. You can go ahead and do those practices consistent with the NRCS standards, and those are normal farming activities. You can be confident in that. And then NPDES permits aren't required for the application of fertilizer or pesticides to farm fields. Matter of fact, farm fields, there's no permitting requirements that apply to farm fields. So not just fertilizer or pesticides, there aren't any permitting requirements. You only need a permit if you're discharging into waters of the U.S. from a point source, so they don't apply there. Whatever you do on dry land doesn't require an NPDES permit. If you apply something directly to the waters of the U.S., then you and it is from a point source, then you need a permit. The pesticide general permit is an example of where there is a general permit that is available for direct pesticide applications to waters of the United States. That's a best management practices-based permit. It's very simple to obtain that general permit where it's needed, but it's only needed if you're applying pesticides directly to waters of the United States, not to farm fields. It doesn't apply to runoff from farm fields. Again, nothing applies from a permitting standpoint to this. And the proposed rule doesn't automatically assert jurisdiction over washes, erosional features, and arroyos. Again, these are things that we have addressed. At least the erosional features, I know the word specifically is in there. Arroyos is something people have said we might want to put some language in there about that. The Clean Water Act applies to some waters that don't flow all the time. So I mentioned that earlier. Seasonal waters are ones that are ephemeral, occur after rain events. But only tributaries are jurisdictional. It has to be a tributary, which has to have a bed and bank and an ordinary high water mark. So if you have a water feature, a surface water feature that doesn't flow frequently enough or with enough volume to exhibit these characteristics, it wouldn't be jurisdictional. So open to any comments you have about those, but we think that the idea that those are all brought in, that's wrong. Has to be a tributary. So the next one says EPA and the Army Corps will not regulate land in floodplains. Actually, it doesn't regulate land anywhere. No land, only water, surface waters. That's it. So it doesn't require a permit to engage in some activity involving a point source on a floodplain or a riparian area. The proposal simply recognizes that waters within a floodplain are more likely to affect downstream waters. So that's what the science shows us, so that's what it reflects. It doesn't require anything different on the floodplain itself. The last point is important also. The Section 404 permit exemptions, such as the one for normal farming and ranching activities, they continue even if they happen in a surface water that is in a floodplain. So those exemptions apply even to jurisdictional waters, but no regulation of floodplains. So the next one is really just sort of a rhetoric point that people have, that proposed rule would not result in a takeover of private property. Some people says it interferes with private property or property rights or water rights. No, it doesn't do that. It applies to surface waters, doesn't apply to land, doesn't apply to rain gutters, doesn't apply to wet lawns, doesn't apply to groundwater. Looks like we forgot mud puddles. It doesn't apply to that. Doesn't apply to dry ditches. It doesn't apply to any of those things. So it's only about waters, surface waters that are part of this tributary system, adjacent, or have a significant nexus with it. It doesn't apply to all these other things. Water rights is a whole can of worms, and that's state law, and this doesn't affect that at all, and it doesn't affect private property rights. If you're doing some activity doesn't require a permit now, it would not require a permit after the rule were finalized. And the federal agencies aren't asserting regulatory authority over land use either. Again, these are just activities that involve discharges into waters, not land use. The Clean Water Act doesn't tell you what you can do on your land. And the rest of this is about what the Clean Water Act is about, and I think I've covered that already, how important it is to the economy. I've mentioned this point already, but just to reiterate it here. So the law was passed in 1972. There was litigation about the scope of the Clean Water Act in the 1970s, but it's been clear since then that non-navigable waters, non-navigable in fact waters, not waters that are used in navigation, they have been protected since the 1970s, and the Supreme Court has 3 times looked at that issue and indicated that that is correct, and it has to be correct if we're going to actually protect waters from pollution, which is the whole point. And then some say that the rule isn't consistent with Supreme Court decisions. We tried very hard to make sure that it was, and have involved the General Counsel's office, both at the Army and here at EPA, in trying to make sure that we looked very closely what the Supreme Court said, and that we can conform the regulations to the Supreme Court cases and to the Supreme Court's interpretation of the Clean Water Act. That is our intent. So if you have comment on that, again, good time to comment on that, but that's what we're trying to do, including that more narrow reading of the Clean Water Act that the Supreme Court gave us than the previous, actually the current rule, the rule that is in effect today, is not limited to match the Supreme Court cases. That's what we're trying to do in this rule. And I sort of feel like I've covered this already. Private property rights or hinder development. The Clean Water Act is not a barrier to economic development. Water fuels economic development all across this country. But if there is an activity that it requires a permit because it involves a point source discharge into a water in the U.S., there are permits available, and they are given out every day by states mostly and the Army Corps to allow for property development, to allow for economic activity, and to do so in ways that protect the environment. By providing clarity, we think the proposed rule, once finalized, will help improve the efficiency and the jurisdictional determinations. Those determinations will be done more rapidly, and then people can move on to permitting and get those permits more rapidly as well. And so we think that this is good for the economy, and we're working very hard to make it as efficient as possible so that people get those determinations. We know people want to comply with the Clean Water Act, so they need clarity so they know what they need to do, whether they need a permit or not, and they can get one promptly. Almost done here for those looking ahead. The EPA and the Army Corps are not rushing ahead with a rulemaking before any peer review of the science. So first of all, keep in mind that the report on connections between waters, the one that the Office of Research and Development is doing for us, it's already based on peer-reviewed scientific journal articles. So all of it was peer-reviewed once already. No new science, no new sampling. All we did was analysis. That's what our Office of Research and Development did. But to make sure that that was good, solid foundation for the rule, we did ask the Science Advisory Board to take a look at it. They are doing that now. The SAB, or Science Advisory Board, it sets its own schedule, but we will not be finalizing the rule until after we get those final recommendations and ORD has a chance to finalize the report. We anticipate the SAB will have completed its work before the comment period now through October 20 closes. So the public will be able to look at that as well and comment on it. And then, of course, the Clean Water Act has a cooperative federalism approach. The whole idea that Congress had, these are very important waters all across the United States. They flow across state lines. They're very important to the economy and to public health. We need to have the federal and state governments work together to protect those waters. So that's the system of the Clean Water Act. This doesn't change that. So it doesn't change the balance between the federal and state governments in terms of our roles in implementing the Clean Water Act. As I mentioned already, water laws and water rights, those are state state water rights. They are in charge of that. They have their own laws, including ones governing water supply. Doesn't change that. And it allows the flexibility for states to decide how to protect the water. So the idea is the Clean Water Act sets a baseline, says these are waters that we need to protect all across the country to make the Clean Water Act work. States can do more, but they also can take the waters, for example, waters that are not flowing all the time, that are not deep enough for people to swim in. They don't have to be protected for swimming uses. States do that all the time. They set standards that are based on what the waters are actually used for. This would not eliminate their flexibility. We retain that balance between the federal and the state governments. We recognize that the states are best equipped to decide what the standards should be. What are the waters used for? What standards are needed to make them usable in the state? And again, this proposal would not change that. Okay, here we are at the end. So the last slide shows you where to get more information. This is the general website for U.S. Waters, and it links to everything else that we've been talking about. It links to the interpretive rule, it links to the ORD report, it links to the Corps' website, it links to everything that you would need, where to comment, everything that you would need in order to comment and understand the proposed rule. And I urge you to take a look at the rule itself. When I've been meeting with people in person, I've been handing it out on one piece of paper front and back. It's a very short rule. The preamble is long, but the rule is short. And you can easily read that and see for yourself what it says, and I really encourage you to do that. All right, we still have a few minutes for questions, so let's see what we have. Jim?
Okay. Thank you, Nancy. And we have a number of questions on here, and we'll get to them. And the first question on here is, and bear with me if I stop speaking since the screen keeps moving on me. How will the SAB review outcome be communicated with the general public? Will it be through a normal Federal Register notice? And if so, when can we anticipate the notice?
So I think it would be communicated online. That would be how we would provide that information. We certainly will put it out so people have that information on the various different vehicles we have as well, like water headlines and so forth, so people have information and can look at what the SAB had to say.
Okay. There's a question about upland draining agriculture ditches that drain into jurisdictional waters. And the question asks, do the exemptions still pertain to the upland agricultural ditch?
Yeah, so we're not extending any jurisdiction over ditches. If you look at the words there on ditches and upland ditches, I'm looking for it here, Jim. Do you have it?
I think it's one of the exemptions in paragraph B for the upland ditches.
Yeah. So there we go, right here. Ditches excavated wholly in uplands, draining only uplands, and having less than perennial flow. So if it meets those three criteria, then it would be exempt. It also would be exempt if it doesn't contribute flow. to one of the downstream waters. So either one of those ways, it would be exempt. It would not be a jurisdictional water.
So, yeah, Nancy, this is Stacy from the Corps. I want to point out that the paragraph B is for exclusions, not for the exemptions. People could get those confused with the activity exemptions.
Okay, thank you.
And I also want to clarify too that we're not changing the statutory exemptions. So the exemption 404 F1C for the maintenance of those drainage ditches and irrigation ditches is also still in play. Yeah.
Good point. Thank you for adding that, Stacy. Okay.
There is also a question here about ephemeral streams that flow into closed basins. Are those ephemeral streams jurisdictional?
Well, it has to be a tributary for it to be jurisdictional. So if it goes into a closed basin and doesn't link to those traditionally navigable waters, territorial seas, or interstate waters, then it is not jurisdictional.
Okay. There is also a question here about the interpretive rule. Does a farmer need a contract with NRCS to take advantage of the 56 exemptions we talked about?
No, a farmer doesn't need a contract. Farmer doesn't even need to speak with NRCS before taking advantage of that. Farmer, of course, can speak with NRCS if he or she chooses to do so. But just all the farmer would need to do is to follow the practice standard, and that activity would be exempt from the dredge to infill permitting requirements.
Okay. There's a question here about floodplains. Which level of floodplains did we consider in the proposed rule? 100-year floodplain, 500-year floodplain, or what?
Yeah, so we did not use those 100-year, 500-year. We did not use that approach in the proposed rule. So instead, we have a definition of floodplain that's based on science, and a welcome comment on that. If you have suggestions on things that you think would be better and why you think they would be better, but it does not rely on any particular size of floodplain like that.
There was a question about, when we talked about the exemption for the upland ditches, is that do we have a definition for upland?
Yeah, so I'm glad you asked that question, because people seem to think that upland means like on top of a mountain or something. So all it actually means is that it's not a water. So it's not a wetland, it's not a pond, it's not a lake, it's not a river. So that is an upland. So in some ways it's really more land. But upland is the term that is used currently in the program, so it's familiar to some.
Okay. And we have a question about what agency does the landowner consult to determine if a isolated body of water and other water under the proposed rule is jurisdictional or not?
Well, the answer to that would be the Army Corps, and so I don't know if the Army Corps wants to answer anything about that, but that would be the answer for them.
No, that's correct, Nancy. This is Jennifer from the Army Corps, and we have 38 district offices around the country that implement the Clean Water Act Section 404 program on a daily basis.
I have a question here that's commented, first of all, is that in the presentation that you did not mention lakes. You talked about tributaries, other waters, adjacent waters. Does this mean that lakes are not jurisdictional?
No, so lakes are jurisdictional, and for example, if you can have an oxbow lake I mentioned, you can have a lake that is in the floodplain or the riparian area, that would be protected as an adjacent water. A lot of lakes are big enough that they're actually used for navigation and boating. Those are protected as well. Yeah, I was focusing really on the smaller surface waters that most of the questions have been about. But lakes would be protected.
Moment.
Oh, yeah, go ahead.
Yeah. One of the things we kind of keep in mind is that in the proposed rule, one of the things that we do not change is that impoundments are continuing to be waters in the U.S., and impoundments are sometimes called lakes too.
Yeah, that's a good point. Excellent. Sometimes impoundments, of course, create lakes. Those are most frequently the kinds of lakes that you find are actually impounded waters.
Okay, and we have time for one more question. And this one is a little bit long. The discharges of dredge and fill material associated with construction, maintenance of irrigation ditches, or the maintenance of ditches have historically been exempt from Section 404. Will these exemptions be maintained?
Yes, every single exemption and exclusion is maintained. So, including that one, and that is a very important one that people are very interested in. And yes, of course, it will be maintained. So we are out of time. So I want to thank everybody for joining us for the webinar today. I'm sorry that I talked so long that we didn't have more time for questions, but of course we are happy to follow up with you on questions. Feel free to contact us if you have questions, and this is your time to comment. This is your opportunity to comment. So please do so.
Okay. All right. At this time, we're going to conclude the webcast. Thank you, Nancy Stoner, and also thank you, Jennifer and William and Stacy, the Army Corps of Engineers. And thanks for everyone who joined us. This ends our webcast for today.